Good afternoon and good morning. Welcome to the Charlie Mike webinar series hosted by the National Veteran Small Business Coalition. Thank you for joining us today. We would like to thank our sponsors, BAE Systems and Philips North America, for making this webinar series possible. This webinar is scheduled for 1 hour and is being recorded. It will be available this Monday, so please look out for your emails. If you have any questions, the mics will be open for this presentation. Again, my name is Earl Morgan. I am the Executive Director for the National Veteran Small Business Coalition. And I would like to welcome our very special guests, and I like to nickname them the two Kellys. And from Morris, Manning & Martin LLP is C. Kelly Kroll. She's a partner for Morris, Manning & Martin. She has extensive experience with federal, state, and local governments, contract formation, and administration. She helps clients in every stage of the government procurement process, from analysis to the risk associated with entering the market to the issues arising during the solicitation, awards, performance, and completion of the government contracts. And her associate, Ms. Kelly Carlson, she's an associate. She counsels clients on performance and certification issues, including small business certification changes, novel COVID-related performance issues, cyber NIST SP 800-717 requirements, and subcontracting and teaming arrangements. She has extensive knowledge of the FAR and DFAR requirements and monitors policies to ensure compliance. Kelly also assists with litigation and counsels clients on all aspects of a bid protest. Welcome to Charlie Mike, and I will go ahead and flip the slide. You could take it away.
Thanks, Earl. Appreciate that very much. So today, we're here today to talk about bid protests. I will stop it shortly, Earl. I think, there we go. If we can get back to make sure we got there we go. If you go to the next slide. Thanks so much. Okay, so again, welcome everyone. And what we're going to discuss today is bid protests, what to do, where to go, when to file, when you either lose a contract award or have an issue with a solicitation, or if someone protests one of your awards. So we'll talk about when and where to file, pre-award protests versus post-award protests, the types of protest grounds we see most frequently, and what you should be on the look for when dealing with government contracts. We'll go over the GAO protest process, GAO standing for U.S. Government Accountability Office, because the overwhelming majority of bid protests are filed there. So we'll go over that process briefly. And we'll also discuss, again, defending your award if someone comes after your contract award. At the end, I'd like to hold Q&A to the end if time allows. But otherwise, you can always feel free to reach out to Kelly or Kelly, myself or Kelly, if you have any questions about this presentation today. I do want to clarify that we're not going to be talking about any other kinds of protests, because there are protests that you can file with regard to size protests, protests that you can file with respect to someone's NAICS code. There are protests that is maybe particularly interesting to this particular group here today. If you think someone doesn't qualify as a veteran-owned business or a small disabled veteran-owned business, there is a process where you can protest the size of or status of an entity who may have won an award and been misrepresenting themselves. So that's separate and apart, something we also do handle. But again, this is just dealing with contract awards. Earl, next slide. Okay, next slide. So where and when? Let's talk about where and when. So basically you have 4 options, possibly a 5th option. The main 3 options are going to either, the agency itself, and the second forum is the Government Accountability Office, the third being the U.S. Court of Federal Claims. On the next couple of slides, we'll talk about the disadvantages and advantages associated with each of those. So, which is important when it becomes time to make a decision about filing a protest. Where should we go? What's the best place to go? And the answer depends largely on what you're protesting, when you're protesting, and other factors that we'll discuss. I threw up a fourth one up here, which is the FAA's Office of Dispute Resolution. They handle their own bid protests, as does the Postal Office. So not everyone can, there are some special limitations, exceptions as to where you can go. Next slide, Earl. Okay, so let's talk about the first place that you can go, which is the agency itself through the contracting officer. You file a protest with the contracting officer, and this is called an agency level protest. The advantages of filing here is that there's a relatively low cost associated with it. There's no cost unless you hire an attorney to assist you with that, but there's no cost for filing that. Sometimes you're able to work it out more amicably, and the agency might actually voluntarily decide to revise or fix whatever you're alleging happened in the protest process, and can do that voluntarily. But the obvious disadvantages of filing a protest with the contracting officer is that you're not going to a neutral party. You're going back to the people that made the decision in the first place that you didn't win the award, or if it's a pre-award protest, that your grievances are unmerited. So you're not going to someone else that's going to put a neutral look into the protest grounds. Also, through the agency level process, you have limited access to information. It's only through the GAO process and through the COFC process or Court of Federal Claims process that you can gain insight, possibly gain insight into your competitors' proposals and what they bid versus what you bid, that sort of thing. At the contracting officer level, it's very minimalistic as far as reviewing the protest. One thing I did want to talk about is if you are thinking about, most of the time what happens where there's agency level protests, it's usually filed in the pre-award context where you're not able to work something out through the Q&A. And just to back up a little even further, just so everyone understands when I say, and Kelly will talk about the Q&A process as well, usually with most procurements, there is a opportunity to ask questions regarding a solicitation terms. And I strongly advise everybody to take, to make use of that Q&A process and ask questions. I often get people that call me after they've submitted a proposal and they'll say, hey, there's this term in solicitation. We don't really understand what it means. Can you tell us what it means? And a lot of times I'll look at it and I'll be like, I don't know what it means, especially when it comes to requirements in the SAO. So it's always best to do that through a formal Q&A process. And if you can't get that resolved through Q&A, going to the contracting officers with a agency level protest can be the most effective way to resolve those protests. When you come to post-award protests where you've lost a bid, it's generally not helpful to go to the contracting officer. And we always usually recommend either going to GAO or COFC. Next slide, Earl. So the GAO, this costs a little bit more. There's actually a $350 filing fee to file a protest. Because much of the information that is submitted to GAO as part of the process is competitive information. It is usually subject to a protective order, and you as a company will not have access to that information. It's possible to represent yourself pro se, but if you do, it's often very, very hard to get access to any information because they don't want to give you a competitive advantage. So you often have to engage counsel when you're filing at the Government Accountability Office. The advantages of filing at GAO are there's a strict timeline. I'll go over that at the end of this presentation today. But if you file at GAO, you know that the case is going to be handled one way or another in less than 100 days. So you have an advantage of knowing and planning for when this can be resolved. One of the other advantages of going to GAO is having an automatic stay if you file timely, and we'll talk about that. Having the award or performance decisions stayed so that the status quo is maintained, and while we figure out whether your argument has merit or not. It's more informal than the Court of Federal Claims. Most of the decisions are made on basis of briefing papers that are submitted. There's no hearings. There can be hearings. It's very rare for there to be a hearing, but there's also a limited record. We don't have like depositions and interrogatories at GAO, so there's less scrutiny given to the overall case. And GAO, for the most part, tends to send out the same types of decisions. So you can usually have a good idea of where they're going to go with a certain, depending on what your issue is, obviously, of how GAO is going to land. The GAO doesn't tend to look very deeply into the, and if there's any GAO attorneys on this call today, I apologize, but that's my opinion. Next slide, please. Okay, so Court of Federal Claims, this is the more formal process. This is where the black robes come in. You have the judges in the black robes, and you have deposition. You can have depositions and interrogatories, more formalities to deal with. It's way more expensive than going to GAO. And again, another reason why many people go to GAO. But if you have a very large procurement and you really think you have very good grounds for overturning an award, the Court of Federal Claims is where some people will go. They'll also go to the Court of Federal Claims if they've missed the GAO timelines, because there are no strict timelines for going to the Court of Federal Claims. Obviously, you don't want to sit on your hands and not file in a timely manner, but the 10-day rules, which we'll discuss for GAO and for the contracting officer, don't apply at the Court of Federal Claims. You also have a right of appeal at the Court of Federal Claims where you can take it to the federal circuit. Again, we've seen that. We've been involved in some of those. They're rare, but when you're dealing with multiple millions of dollars, sometimes it's worth incurring that cost, especially again if you have very valid protest grounds. There's no automatic stay of award or performance at the COFC. Usually what will happen is you will file and an agency will usually agree to stay performance. It doesn't always happen, especially if the agency is eager to get moving on whatever the contract award is dealing with. If they don't agree, you of course can go through the process of trying to put an injunction in place, and the court will entertain that. But again, that adds to the formality of the process, adds to the expensiveness. I mean, when I have people call, you're talking about a minimum of probably, $150,000 just to kind of get started here. So you can see there's a difference in the cost with these different forums. So it's very rare for people to go to COFC, but it is an issue. The other thing that's kind of an advantage is that at this level, the Department of Justice gets involved with the task order process. They can often put a different perspective on it. So sometimes just by filing at COFC, and we've used this as a strategy before, by filing at COFC, you kind of get everybody's attention, and then the parties can sometimes work everything out. And at that point, the agency may decide to back off and take corrective action and review, and by corrective action, I mean review the proposals again or review the solicitation terms again, take a look at it again. So sometimes it's helpful because the DOJ might be able to make the agencies realize that perhaps they made a mistake. Agencies are don't usually want to admit they made mistakes in procurement reviews. But when a third party like the Department of Justice attorneys get involved, sometimes that happens. So sometimes that's a strategy. We've done that before. We said, well, let's file, let's see what happens. And if nothing, we can always withdraw because that is always an option. Next slide, Earl. The last thing I wanted to turn before turning this over to Kelly is that not all solicitation terms and awards can be protested. Specifically, there's limits to task order protests. So you have an overlying master contract, an IDIQ, or GWAC or MAC, whatever you want to call it. The task orders that are issued under these types of contracts can only be filed at the GAO. The COFC does not have jurisdiction over these task order protests, and then even then at GAO, the task orders have to meet a certain value. For if it's a task order that's awarded under a civilian agency, then the task order has to be at a $10 million or more value. If it's awarded by a DoD entity, then the task order has to exceed $25 million. One exception to that is GSA task orders can always be protested. And then, you know, regardless of the dollar value, they've made an exception. This was all enacted by statute, I don't know, probably 10 years ago, maybe more. Time flies when I get older. And there was just everybody was protesting every single task order. So they enacted a law that raised the bar for these task orders. But you can always protest a task order that gets issued if there's a reason. The buzzwords here is that it increases the scope, period, or maximum value of the master contract. Those can be filed with the contracting officer or at the COSI because it's changing the scope, like they're adding new work to the contract without reawarding the master contract. Then you can protest these types of decisions at COSI. And so again, and just to reiterate, we are talking, there are a lot of nuances to bid protests. And so today we are really talking at a very high level, but again, we're available to talk to people about questions they may have either today if we have Q&A, and then also just give us a ring later on down the road. And so with that, I think Kelly's going to pick it up and talk about when to protest. Correct, Kelly? Kelly, your mic's on.
Gotcha.
There you go. I hear you.
All right. So I'm the second Kelly of a Kelly dynamic duo here. Thank you, Kelly, for covering the. Sorry, Earl, I have a little bit of feedback. Okay, it stopped. There we go. Kelly Kroll had just talked to you about the different venues in which you may file a bid protest. I'm going to talk about when to file. So she covered the where, I'll talk about the when, and then we will dive into what a pre-award protest looks like, vice a post-award protest, and potential grounds that you can establish under each in each context in order to establish claims. All right, and we do have some new people that have joined us. Thank you for joining. Just a reminder, we will keep Q&A till the end, and I think a recording will be available online at a later date. All right, so Earl, you can go ahead and proceed. Thank you. So for the question of when to file a bid protest. So, and we're going to fly through the next few slides because it gets a little repetitive, and that's okay. We want to drill some things into your minds with respect to bid protests, one of those being timeliness. So most pre-award protests must be filed before the proposals are due. That's in juxtaposition to the post-award protests, which are filed after proposals are due, after the awards are made, and we'll cover that in a bit. So failing to object to solicitation provision pre-award might result in a waiver of that protest argument. Again, that goes back to this timeliness requirement. So just bear that in mind. So you might be thinking, why would a contractor, why would they not wait until after the award is done to file all of their grievances with the agency? That's why, because you might waive things that you didn't intend on waiving. Okay, and you can go to the next slide, please, Earl. Okay, and in the post-award protest phase, there are a couple of main deadlines you want to be aware of. Sorry. So one is the filing deadline, and the other one is an automatic stay of the award or performance. So the stay has a much more protracted deadline. For the filing deadline, the protest must be filed within 10 days of when you knew or should have known the basis for the protest. So as you may assume, there's a lot of gray area baked into that assumption, and so that's something that comes up frequently. The other side of the deadlines that we need to be aware of are the automatic stays. So that must be filed within 5 days after a required debriefing or within 10 days after award, whichever is later. And because these timelines are so protracted, as we said, Kelly had mentioned that this is kind of why people wind up not going to GAO, because they miss the boat on these deadlines, and they have no other option but to go to COFC. All right, you can proceed. Thank you.
I just wanted to jump in on the timeline really quick. These timelines are very, very tight, and as Kelly mentioned, and the number one rule from GAO decision is late is late. We call them late is late decisions, and we've done work where a protest was filed 1 minute after 5:30, which is the closing time for GAO. We've done them, you know, where the systems were down, etc. But you have to be, if you have any indication that you want to protest, that you feel like you have an issue with either solicitation or a contract award, the first thing to do is to talk it out. Don't try to analyze it internally, because we need to understand what the deadlines are. Just wanted to jump in on that real quick.
Sure. Yeah. Okay. So these are questions that you will want to ask yourself as the contractor considering a bid protest, and these will keep coming up over the course of the rest of the presentation, so just bear them in mind. A lot of them have to do with standing requirements, prejudice requirements, so that's where these are coming into the fold. So are you an interested party? That's part of the standing requirement. Like, are you a contractor that even has the capabilities to respond to the solicitation? Do you have factual and legal support for your protest? Your protest cannot be based on subjective opinions. Oh, I have a better business process than XYZ contractor that was awarded the contract. That would not be sufficient. Are you in a strong competitive position? Again, are you an actual competitor, or are you even operating in this space of business? Are you in the industry, you know, under the NAICS code, et cetera? Are you an incumbent? Incumbency usually goes to standing in the pre-award context. So we won't get into that too much, but just know that that's a consideration in that context. Are there considerations related to teammates or the customer? So again, we will continue to build out this set of questions that you want to ask yourself as a contractor that's considering a bid protest. But for now, just bear those in mind, and we can go to the next slide. All right. So I mentioned I would get into pre-award protests versus post-award protests and how they compare, contrast, and the grounds that you may consider bringing claims under each one. Pre-award protests are, as the name says, filed before the proposals are due. Okay, next slide. So what is a pre-award protest? What does a normal remedy look like when you're filing at this stage? It's almost always a challenge to the terms of the solicitation. So this is a useful tool when you want to address issues in the procurement process before the evaluation and award. And again, we mentioned that issue and that caveat that if you don't bring up an issue in a timely way, you may waive it. So that's again a big reason for why you would consider filing pre-award protests. And Kelly had mentioned the Q&A process. So just want to bring that up again to reiterate that you as the government contractor should be focused on being engaging with the government customer, potential customer, and also being positioning yourself so you're coordinating with them. That will paint you in the best light as a government contractor. So one of the ways that you do that is by engaging early on in the Q&A process and by asking questions, trying to resolve things at the get-go rather than waiting to file a bid protest. The remedy that is sought at this stage is usually an amendment to the solicitation or an extension of time. Sometimes the extension of time is an amendment itself. So we can go to the next slide and talk about the different grounds upon which you may bring a pre-award protest. We'll run through several categories again of these. Again, this is not an exhaustive list, so just keep that in mind. These are examples. Some are ones that we come across frequently, others are a little more nuanced. So the first category are improprieties in the solicitation. So if the government has unduly restrictive provisions and doesn't have a reason for that, like they put in some requirement that's not needed in order to meet the minimum requirements of the solicitation, then that could be seen as actionable because it's just not necessary. Patent ambiguities, exactly as they sound, these could be things that are just blatantly wrong in the solicitation. they could be inconsistencies or things that run contrary to one another. Let's say in one section of the solicitation, it says a program manager needs 8 years experience, and then another, it says 5. That's a patent ambiguity that needs resolution. And if it's not, it's actionable. Inclusion or exclusion of required clauses. So one big example that may come up is if a Buy American Act provision is included erroneously. So it's a big deal because you may recall that this requires government contractors, the government, to buy domestic end products. And so there's this preference, and that's a problem for government contractors today who have more of a worldly presence. They use international distributors, suppliers, manufacturers in their supply chain and their product development chain. So this could be very onerous to comply with. If it's included in the solicitation, then it could erroneously leave contractors out of the bidding process when they actually, could be a part of the bidding process because that requirement shouldn't have been there in the first place. So that's actionable. Insufficient information. The contracting agency has to allow the offers to bid in a meaningful way and to respond in a responsive way. So if there's not enough information in the solicitation, then that inhibits them. That's actionable. As is incorrect solicitation type. So this happens, for example, when the contracting agency wants to procure a certain brand name. You can't just go out there and say, I'm an Apple fanatic. That's who I'm going with as the government. Not when Android can accomplish the terms of the solicitation just as well. So if the agency is going to procure brand name, it has to follow certain steps. It has to have certain documentation in place, such as the justification, and any of these missteps in the process or documentation could be actionable. And then lastly, unreasonable evaluation method. So the government can't just erroneously and randomly assign weights and values to criteria and subfactors without explanation. You'll notice this other theme here, which is the government has to have cognizable explanations for everything it's doing and has to be based in rational. It has to have rational basis to what they're doing. They have to document things properly. If they don't, all of that is actionable. So they can't just tell, government contractor, oh, you get a weakness for XYZ competencies, but then the other contractor gets a strength for the exact same competencies, even though they have a less of a history of being able to produce on those competencies. It has to be fair. Okay, we can go to the next slide, Earl. All right, so the other category are procedural concerns. We won't spend much time on these because they are as they seem. Last minute amendment to the solicitation will be problematic. The government can't just substantively amend the solicitation and then not give the bidders, a chance to respond in a meaningful way. So if it's a typo or an extension of time, obviously that's not a problem. That's not what we're talking about here. We're talking about substantive being an issue. Cancellation altogether, that could be viewed as the government acting in bad faith. And then scope of proposal revisions. If the agency changes one aspect of the RFP, then it has to be cognizant that that could impact other parts of the RFP. And it needs to allow the contractors an opportunity to amend their proposals in connection with whatever changes were made and any changes that might cascade down through the rest of their proposal. So whenever the government is kind of taking these procedural steps and not paying attention to the impact it has on the contractor, that could be actionable.
I just want to jump in and say that some of these protest grounds, while they are actionable, some are more successful than others. Kelly mentioned bad faith and the cancellation of solicitation. While we've dealt with protest grounds like that, those are not as successful. Bad faith is really hard to prove against the federal government. But these are definitely types of things to look for, think about, talk about. But some are more likely to succeed than others. And so just wanted to point that out.
Yeah. Thank you. It's a good point. And so, Earl, we can move to slide 16 and cover the last pre-award protest grounds category. This is more of a nuanced one as it pertains to small business issues. So first we have the rule of two. Agencies have to abide by this rule, and as a reminder, this rule says that the agency has to determine if there are two capable and interested small businesses before it determines set-aside eligibility. So if there are two qualified small businesses, then it has to do a set-aside. If it doesn't follow the rule or it fails to document things properly and do its market research properly, then that could be actionable. Another one, removal from the 8A program. So this happens with follow-on contract work a lot. So if there was an original contract that was designated for 8A program and the contracting agency wants to remove the work from under the program's purview and open it up to other potential offers, then it needs to follow the correct procedure and documentation. And then lastly, it also has to abide by the hierarchy of the set-aside programs. So is the government following the hierarchy? Is it documenting things? So government wants to procure number 2 pencils. There's obviously a plethora of contractors with the ability to fulfill that requirement. The government has to set aside the procurement for special interest groups, and it has to do so in the correct order. So, ability 1 for the blind first, federal prison industries next, so on and so forth. And any failure to abide by any of these rules and requirements are actionable.
And of course, as it pertains to the group here today, also obviously where contract opportunities are not set aside for vets or SDV OSBs by the VA. That's been protested, litigated, settled, but and I think the VA has gotten it together and hasn't done that, but I guess it could still come up from time to time, but that would be a protestable issue. Again, depending on the facts. And the caveat for everything we say today, it all depends on the facts, and which are very important.
Yes. Thank you. Okay, Earl, we can go to the last slide in this section for pre-award protests. I will quickly cover the protest remedies and some final remarks about pre-award protests. So some of the remedies include the agency agreeing to take corrective action on its own, or the GAO may direct it to take corrective action. The action that it has to take may be an amendment of the solicitation or extending the deadline that contractors have to respond to the solicitation. If nothing can be resolved within the if nothing can be resolved unofficially or in terms of amending the solicitation, then the protest may be sustained, meaning it can move forward. And then lastly, attorney's fees might be on the table if the claims are meritorious enough. Basically, the GAO may say, okay, you were at a large disadvantage. It wasn't inconsequential. It was worthy of getting attorney's fees and in internal protest costs. So that may or may not be on the table, depending. The recommendation for any of these actions that may be taken by GAO or agency depend on the basis for sustaining the protest. So it'll all come back to the issues at play and how are we going to rectify the issues. All right, next slide. Okay, so we just covered pre-award protests. Now we will jump into post-award protests, which are much more common than pre-award protests. Next slide. Okay, and you may guess the reason why is because there's simply more of a record at this point. There's more information, more documents equals more potential protest grounds. So we do see post-award protests more frequently. It's, as the name states, it's almost always a challenge to the award of the contract. And GAO's regulations require the agency to produce all documents that are relevant to the protest. So maybe not, we won't see as many as those produced at COFC, and the discovery process isn't as extended as that at COFC, but there's still a much bigger record to go on than there was in the pre-award context. And just note that these documents produced are subject to protective order for attorney's eyes only. So if you're thinking, oh, I'm scared to submit a bid protest because of my confidential information, PI, trade secrets, just know that that's not going to be a deterrent. It's not an issue because of the protective orders in place. And at this stage, you'll want to assert as many grounds as possible. You may uncover new grounds once you get a hold of the entire record and all of the information, but you do have to maintain, legal sufficiency and factual sufficiency in your bid protest. I can't come down to opinion, can't say I know I am better than that contractor that was awarded. It has to be based in these two things, and also you have to be able to demonstrate prejudice, which we had mentioned earlier on is part of the entire standing analysis. And, we won't get into standing in a larger discussion here. We do have a mixed audience, but just as a reminder, it is comprised of being an interested party and did you have an injury? In the post-award context, this would be substantial chance injury. The prejudice piece is, was your injury unique? Did it result from the action that the agency took erroneously, or yeah, that's all I want to say about that.
I think that the two takeaways I would have everybody take away from this slide are the last two bullets. We often have clients come in, call, and they lost an award, and they'll say, well, I know I'm better than them, or I know they don't have the people this. There's a whole line of GAO cases dismissing cases before, saying that they were based on information and belief. Information and belief is not going to get you to the, through a protest. There's got to be solid facts backing up whatever your protest grounds are. And then the last one, in a more simple stated fashion, is that you have to show, but for the agency's actions, you would have been in line for award or would have won the award. So we often have people that come in and they'll say, because during the debriefing, an agency might give you a list of all the offerors, and there were 20 offerors and you were number 18 on the list, but you think you were misevaluated for whatever reason. Well, what if it was the first, the person who won didn't have the capabilities? Well, great, you knock number 1 out, but then number 2 wins, and how long is it going to take till we get to you at number 19? So that's what we talk about when we mean about demonstrating prejudice, that you have to show you were at least in line for award, but for the agency's actions.
Okay, and we can go to the next slide, slide 20. So now we will move into the potential grounds on which you can file a bid protest in the post-award context, and the categories for each one. Again, not exhaustive, just exemplary. Technical factor evaluation tends to come up. So this is just the agency failing to do what it says it's going to do per its solicitation terms. So if it says it's going to evaluate the solicitation, the bidders and their bids in a certain manner and in accordance with certain criteria, and it fails to do that, that's actionable. As is the agency applying unstated evaluation criteria. So this is something that the agency decides later on that it's going to evaluate on, that it doesn't actually include in the solicitation outright. So maybe this is a requirement that a program manager has to have 5 years of experience as a PM, but then it erroneously assigns a weakness to the PM provided because that PM didn't have a certification, like let's say PMP. But that was not identified as a requirement in the RFP. That's unstated and that's actionable. Another one, the awardee failing to satisfy material requirements. So maybe the contractor that was awarded didn't have licenses that they needed to have. They didn't have security clearance, facility clearance. They didn't have the correct personnel. They didn't have key personnel. Those would be actionable things. Another one, the awardee misrepresenting that it had any one of those things or misrepresenting anything about its capabilities. Another one, unequal treatment. So this whole disparate treatment issue keeps coming up. The agency has to treat all of the offerers as fairly as possible, and there should be an equal playing field. If not, then it's actionable. Another one, the agency misreading the proposal. They could just blatantly be misinterpreting something. Maybe they failed to read part of your proposal. Okay, next slide. We are now going to talk about briefly past performance factors that may lead to post-award protest grounds. So one is failure to follow the evaluation criteria. We kind of just touched on that on the other slide. So the agency has to follow its own criteria. It has to apply the same standards across the board. The agency also has to know when to credit the offerer. So, you know, why wouldn't commercial work that like a Deloitte completed on its Lockheed Martin system software implementation be relevant to the IRS's system implementation using that same commercial off-the-shelf software? If the government has a reason for that and it's based in something real, then fine, but it should be documented. If the government doesn't have a reason for that and it's not crediting the offerer with that experience, then that could be problematic. Another one that we've mentioned again and again, disparate treatment, have to apply the same standards. And then failure to consider close at hand information. So this doesn't really come up that often, but it would be like if, and that's because, you know, the other reason why it doesn't come up that often is because as the contractor, you want to make sure that your offer and your proposal is as detailed as possible and as responsive as possible. You don't want to leave things out of your proposal, even if they are obvious. But if you do, there's this concept that the government should, if they know something about you personally, then they should give you credit for that. So if you're the incumbent on a NVSBC contract at the Warfare Center doing some function, and then you fail to put that into your proposal for an NVSBC contract at the comptroller office, just a different office, same agency, then the agency should know that you had that experience. That's the idea. But again, like, just make it incumbent on yourselves to make sure your proposals are responsive in the first place. Okay, we can go on. So another one is cost and price factors. So again, this one comes up pretty much on every slide, a failure to follow evaluation criteria. So the agency has to be hold itself to the terms that it holds out for itself in the RFP. And if they don't, then that's actionable. If they're performing a cost or price evaluation not called for, or failing to perform the evaluation that's contemplated, that would be an issue. So this would be like if the agency is doing a best value determination instead of the lowest price technically acceptable that's called for in the RFP, you know, or vice versa. Unequal treatment, again, in terms of cost or price. So you can't, the agency can't kind of give any hints to one contractor that it would accept a certain price over another one. In that context, that would be unequal treatment and actionable. The agency has to make sure that all of its assumptions on which it's basing its evaluation are based in something real. They're fully documented and rational. So this might come up when the agency doesn't have correct assumptions built in. When the agency's IGCE is incorrect, as a reminder, we don't like to just throw acronyms out there without explaining them. IGCE is the Independent Government Cost Estimate. So this is the thing that allows for the government to develop an assessment of the probable cost of services so that it can determine, you know, a good value for the government when the contractors are submitting their bids. So if they produce a faulty one, then obviously their assumptions might be flawed and they might be basing their entire evaluation on incorrect cost factors. Okay, we can move on to the next slide. So I believe this is our last category of, nope, second to last category of post-protest grounds. And it's kind of a miscellaneous category, so we'll go through it quick. Misleading discussions, unequal discussions, lack of meaningful discussions. So the agency, again, it just must treat all offerers equally. The agency can't tell one offer has a deficiency because of its staffing is being insufficient and then tell another offerer with the same staffing that their staffing is fine. You know, they can't back into the contractor that they want or that they favor by doing things that are disparate among the competition. Another one, OCI, they have to handle that properly. So the agency, if the awardee was selected and has organizational conflicts of interest that weren't even considered, that's actionable. As is the agency not even attempting to create a mitigation plan for someone that did have OCI and they erroneously took them out of the evaluation and took them out of the competition prematurely. Lastly, impermissible responsibility determination. So this is nuanced also. So in the small business context award, if a small business is deemed not responsible according to the definition in the regs, then the SBA has to get involved and they have to contemplate issuing a certificate of competency. If the contracting agency fails to involve SBA in this limited circumstance, then that's actionable. Again, that's a nuanced one, doesn't come up, well, it might come up frequently, but it's not a universal thing to worry about. Okay, next slide. So this is the biggest one because it's based on the award decision itself and not all of these things leading up to the award in the post-award context. So an improper or non-existent best value trade-off. So if the RFP says the award will be made using best value, then it has to assess the costs and strengths and weaknesses to justify the award. It has to involve all of those things in the assessment. So that's why. It has to be able to show that either it was a lower price, technically inferior proposal or higher price, technically superior proposal. If it doesn't do this best value trade-off, especially if it says that it was going to do the lowest price technically acceptable, then it's actionable if the agency kind of switches the evaluation method without notice to the contractors, or it doesn't follow the procedures for converting them properly. The last one here is improper sole source award. So sole source comes up when, obviously when the agency has tried to pursue a sole source erroneously. Sole source is only allowed when there's one responsible source able to satisfy the agency requirements. If there was more than one and there was no exception that the agency could meet, then it can't select sole source, and it did that erroneously. This is actionable. So we can go on to the last slide in this section, Earl. All right, so to round out the post-award protest discussion, we have a few remedies and final remarks here. So the remedies that you can get at this stage are a stay of the award, postponement of the award, or continued performance of the award. So, we have to remember, and Kelly will talk about in a minute, how if you are the awardee, you might be intervening on your own to defend your own award. So in that case, you would want the remedy to be continued performance of the award, obviously. Strongest arguments in the post-award context are going to be clear-cut. They're not discretionary. So deviations from the solicitation, disparate treatment, insufficient documentation, any flawed or unequal discussions that are being had during the evaluations. These are always going to be more so winners than anything that are subjective. And lastly, we do want to drive home the point that prejudice is paramount. Like Kelly talked about, it has to be an injury that happened an injury that would not have happened but for the agency's action that it took erroneously. So if you're 7th in line, that's probably not going to do it. If you're 2nd in line for the award, then you will likely be able to meet the prejudice requirement a lot easier. So thank you for bearing with me on that. And now we are going to transition back to Kelly Kroll, who will walk you through the GAO bid protest process.
Thanks, Kelly. Yeah, I mean, we're going to talk about the bid protest process at GAO and the success rate of these protests that are filed. There are some that are slam dunks, and there's some that are we'll tell you, if you come to us about them, we'll tell you, you're not, this isn't going to do it, or you got a shot, so slam dunk protests. The one I always give as an example is if you're working on a GSA schedule order and your competitor that was awarded the contract doesn't have the items that were solicited on their GSA schedule, that's considered outside the scope. That is a slam dunk protest, and so whenever somebody comes to me with a GSA protest, that's the first thing I do is I look at the awardee schedule and say, did they have everything? Did they have the capability? Did they have the people? So that's that, but there's other ones that are definitely gray matters. And, the success of those protests necessarily depends on the facts of each case, which need to be analyzed. But let's say that you decide you do want to go to protest, and we're going to talk about GAO again, because that's where the overwhelming number of protests are filed. Next slide, Earl. Okay, so this is a protest. This is the 100-day timeline. So this is what generally what happens is you file on day 1, you pay your $350 fee. The GAO filing docket is all online at a system called EPDS, and the agency is notified if you file timely. Well, they'll be notified regardless, but if you file timely, they'll confirm that the contract performance or award, depending on which stage you're in, has been suspended and stayed. If we're talking about a post-award protest, and let's talk about this in post-award context, the awardee is notified because they're told to stay the performance. The awardee then has an option where they can intervene. They can file online and intervene in the protest. GAO, as we've mentioned, will issue a protective order, which all the attorneys have to sign off on. During the day 1 to day 30, all that is going on. But also what can happen during that day 1 to day 30 is that the agency can file a motion to dismiss. They could argue that the award was not, the protest was not timely filed. They could also award that the protest is based on information belief and there's insufficient, facts to support a protest. And GAO will entertain those motions during that 30-day period and subsequently. But the 30-day period, day 30 is important because that is the day in which the agency will file what's called the agency record or agency report, and that include, depending on what the protest grounds, that will include different information from the award decision. If you are protesting only the award and the evaluation, the evaluation of your own proposal, let's say you lost the award, you don't think you were evaluated properly. If that's your only protest ground, you're only going to get access, or your lawyers are only going to get access to how the agency evaluated your proposal. In order for your attorneys to get access to the proposal and evaluation of the competitors, you have to raise some kind of protest ground that their evaluation was also improper. So that's when we talk about raising as many protest grounds as possible. The more protest grounds you raise, that gives you a reason to have your attorneys to have more access to the full record. If after the date, if the agency has not moved to dismiss and they file the agency report, that means they're going to defend their award decision. After day 30, there's 10 days for which the protester to reply or file their comments on the agency report. If the awardee has intervened, the intervener can also, and I'll talk about the interveners shortly, but the intervener can also comment on the agency report. GAO may elect to hold hearings. I've in like on all the years I've been practicing, I personally have only been involved in 2. So it's very rare for them to hold a hearing. It's usually when the issue is not sufficiently developed in the record. And on day 100, assuming it's gone that far, GAO will issue a decision. And if the protest is sustained in favor of the protester, or the agency unduly takes corrective action, because sometimes the agency will take corrective action between day 40 and day 100 if it feels like it's not going well. The protester can request bid and proposal costs and attorney's fees. The attorney's fees are limited, but we've done that before and been successful in that, recovering that money for protesters. So that's the process in a nutshell. Can we go to the next slide, Earl? And so again, Kelly talked about these. The protest incomes are you either going to win or you're going to lose. Denial, you win. I'm sorry, denial, you lost. Sustain, you win. You can also withdraw your protest at any time. So we often tell people, like, look, let's file the protest. If it's not looking good based on the agency record, we can withdraw it. And that has happened where we've looked at what the agency has done and we're like, we're going to lose. The agency crossed all their I's and dotted all their T's. And yes, you guys did forget to submit this, that sort of thing. So you can always withdraw. A lot of times the agency will take corrective action. And I realize I'm going in reverse order on this list, but the agency will take corrective action. Again, they'll say, okay, we'll go back to the drawing board. We'll reevaluate proposals. We'll hold discussions with all the offerers and let them submit new FPRs, final proposal revisions. But then also in that 0 to 30 day window, you have that dismissal where if you're untimely, you're untimely. Late is late. And so GAO cases can often end that way. So there's what rarely happens, and I think what's important is even if you win your protest, GAO is usually just going to tell the agency to go back to the drawing board. They are not going to direct the award. I can't even think of in recent memory of when that's happened. They're not going to go, let's say you, ABC company, filed a protest and GAO might say, yes, ABC was right. You agency, you evaluated their protest incorrectly. They are not going to say to the agency, hey, award the contract to ABC, take it away from XYZ and give it to ABC. That's not going to happen. What they're going to say is the agency, go back and look at everything again. And what can happen, just so you're aware, even though you've won and it's been sustained, the agency can go back to the drawing board and come back out and say XYZ wins. That can happen and has happened. So sometimes what ends up is it's just giving the agency an opportunity to go back and cross their I's and dot their T's. So we've seen that, but we've also seen when a protest has been sustained, where they go back and then the protester does win the follow-on work. So there's no guarantee with any of that, but those are the possible outcomes. Next slide. Just in the interest of time, I'll skip over this. You can pause the recording later and look at these. But these are statistics of how many bid protests are filed. They seem to be decreasing every year. GAO has closed most of its cases in 2022. That's government's fiscal year 2022. You can see that only 455 of these cases of the 1,600 went to the merits, went to that 100-day timeline, because most of these things end in corrective action, which again can still be helpful and can still kind of reset everything. So based on that, GAO reports an effectiveness rate of 51%. Next slide. And we're going to go a little bit over here, and I understand if people need to leave, but for the recording purposes, we'll carry on. Defending award, again, this is when you are bidding on a contract and you won the contract and someone protests it. Next slide, Earl. You usually have the right to intervene. There's very limited reasons when you wouldn't have a right to intervene. But the reason you want to intervene is there's numerous reasons, right? Number one is if you don't intervene, you're not going to know what's going on. No one's going to tell you what's going on. You want to intervene, you want to get lawyers so that lawyers have access to the information and what's going on. Now, under the protective order, we can't tell you a lot, okay? We can't disclose any of the competitors' information. We can't disclose arguments. It's all very, very high level, but we can at least keep you apprised of what's going on. What we can do too for you as an intervener is we can assist the agency. Sometimes agencies aren't up to defending the award. They want to. They're overwhelmed. The agency attorneys are busy. And so we can assist them and work with the agencies to defend the award. So, this is, and one key area where I think it's always important to intervene is if you're the incumbent. If you are the incumbent, and you've lost the award, I think it's a no-brainer that you need to intervene because of again, just keeping tabs on what's going on with the procurement, because you're the incumbent, you'll probably get awarded a bridge contract, you can carry on work, but you need to start planning and figuring out what's going to go on and have an idea of, because as attorneys, we can kind of give you this is where we think it's headed kind of thing. So that is it in all. And if there's anybody that had any questions, again, I think because of time limits, we'll let this go out, but please feel free to call. Earl, I think our stuff's on the last slide. Is there one more slide, Earl? There we are. There's our emails. So you can contact us by email and be happy to assist you to the extent we can. So I will just conclude by saying thank you very much for participating today, and we hoped this was beneficial to everybody who joined.
Okay. Well, we had about 7 people on here. Now we got one left. Matt,
and I see it's Matt Lanning, and I know Matt Lanning. Matt, we're putting you on the spot.
So, Matt, do you have any questions for us? Your mic is on.
I do not have any questions off the top of my head. I do think that that this may be helpful down the road with the one that we're currently bidding, though, Kelly.
Yeah, this is going to be made public, so don't disclose. But yeah, we might have. Matt is an existing client of Morris, Manning, and Martin, and so he may have some protest issues down that. That's probably why he's logging in to get a. But happy to help you, Matt, as always.
That's right. I'll just put a shameless plug in. Kelly are both great, so use them as necessary.
Thank you, Matt. I appreciate that. It's very nice.
For sure.
That's awesome. Anyway, for you folks who are watching on demand, you have Kelly and Kelly's contact information. If you have any questions, please contact them. And again, Kelly, thank you so much for doing this for us. I know you guys were extremely busy, as we talked about earlier this morning. So thank you again. And for those of you who are left, Matt, you're left. This recording will be sent to you on Monday. Okay.
All right.
Sounds
thank
good.
you, Earl.
Thank you.
Thanks
Thank you
much.
for having us.
All right.
Bye,
Thank
everybody.
you very much. Thank you. Bye.